FRKelly in Cork. We're based in the Republic of Work offices on the South Mall. We also have offices in Dublin and Belfast. The firm employs around 60 people with 30 or so professionals, which cover all of the areas of intellectual property, including patents, trademarks, copyright, designs, and trade secrets. And intellectual property is our expertise. Just a couple of housekeeping notes for today. Please mute your microphone. We will take questions at the end of the session, or if you like, you can put them into the chat function, and the speakers or myself will endeavor to answer these questions during the presentation. Today we have a stellar lineup for you of 3 partners in the firm who have, I just counted up, a combined experience between them of almost 80 years of intellectual property experience. One of them might have a little more than the other 2. So the 3 speakers are Paul Keane, who is a West Cork man, a graduate of University of Limerick and UCC, and with expertise gained from working in the Tyndall Institute. And Paul is a European patent attorney and an expert in software and electronics. We've also got Shane Smith, who is also a European patent attorney, actually a solicitor and a European trademark attorney. And Shane has written a book some years ago, which has been updated and is now the primary reference source in Ireland for intellectual property in the state. David Brophy is a European patent attorney, a physicist, and also someone with exceptional expertise in the area of designs and copyright. David having studied, I think it was at Queen Mary College in London, as well as Trinity College in Dublin. So I'm going to hand off straight away to our first speaker, Paul Keane, to talk about patents. So over to you, Paul.
Yeah, hello everybody. That was a nice introduction, Phil. Just want to make sure everybody can see my screen. I think you can. It should be shared now. Yeah, so as Phil said, I'm a Cork man. I went to school in Skibbereen, St. Falkland's de la Salle, and I work a lot out to the Republic of Work in Cork and the South Mall. So, you know, if there's any, feel free to reach out to me afterwards if you have any questions on this topic or my colleagues. So I said I'm a European patent attorney. My background is electronic engineering, and I also have a higher diploma in microelectronics from UCC. So I suppose FRKelly in the patent department is broke up into different areas. It broke up to electronics and software, which myself and David work in, and then we have life sciences department, and we have a mechanical department. So we have a specialist team to suit depending on the type of technology, you know. So I might as well kick off because I'm under 10 minutes on my stuff. My stopwatch has started. So patents. Basically, patents are a form of intellectual property that is used to protect the technical innovation. You know, it doesn't just protect aesthetic looks. You know, there are other forms of IP that my colleagues will discuss. This really is used to discuss how something works. You know, and normally when we're determining if something is patentable, we look to see what products or inventions are already exist, and we call that prior art. And then we look at the potential invention and we see if there's some overlap. But what we're really trying to identify then is the invention, and the invention is the new part. So I think a simple Venn diagram is a good way to look at if you have something patentable. Are you doing something that's different? Then if you're doing something that's different, that has a technical, provides a technical solution, then potentially you have something that is patentable. So often people think about patents and it's very complicated, but in a nutshell, it is actually a very, very straightforward process to go and get a intellectual property and get your patent protected. There's some basic criteria for patenting. The most basic is that you have to have novelty. And what we mean by that is that you have to have at least one aspect of your product or your process or your system or your method that's new. It's only one aspect that you require to be new. So that's and the second important criteria is that your new aspect has to have an inventive step, and this is patent language. But what that really means is that you have to your addition to the existing world of prior art, you have to provide an advantage. Really, that's in a nutshell. You have to provide some sort of technical advance over what's already out there. So they're two basic criteria: novelty and inventive step. There is a third criteria. It's called industrial applicability, but the reality is that everything is industrial applicable. So when patent examiners are looking to see if something is patentable and meets the criteria for an invention, they're really only looking at novelty and inventive step. And they're two basic criteria. We look at what can be patented. In a nutshell, a patent is a document that details a solution to a technical problem. So the first thing is that if your invention has to be technical and it has to provide a solution to a technical problem, and what do we mean by that? Well, there is no definition of what invention or what is patentable in any jurisdiction. It's quite general, So, if you're looking at your own products or systems and you think, well, I have a problem, I've solved a problem, I provide a technical solution, then potentially it is patentable, And what we look at is if you have a new aspect, so for example, you might add a new module in software, and then you look at, is it inventive? Well, if that new module adds 10% efficiency or 5% efficiency in some sort of process, then potentially you could have patentability. So that's the basic criteria. You look at what I'm doing, is it technical? Am I providing a technical solution to a technical problem? And often people when they look at patents, they overcomplicate it. As I said, this is just a slide that somewhat repeats because there is very little, the criteria is quite basic. So it's good to get this concept into your head, Am I providing a solution to a technical problem? And if you are, I think it's a good idea to consult a patent attorney to do more investigation then against the prior art to see if it already exists, and then would do further investigation as potentially have you that inventive step criteria or potentially have it. So there's big belief out there for many years. I've often given presentations that people say, Paul, software isn't patentable. And the reality is that is a complete and utter misunderstanding. I'd say about 90% of the work I do is software related, So again, it's the same criteria for software as any other form of technology. And I'm only focusing on software because my background is electronic and software. But if my colleagues in life sciences or in the mechanical department, they would have similar slides in a different area and more in their direction. So if you're joining today and you're not interested in software, that's fine. We have colleagues that would be able to give you an opinion on patentability based on their own technical area. But just this is a slide about software. You have a squirrel with a red eye, and you take a photograph, and the difficulty when you have a photograph, it doesn't look nice. Okay, so if you can provide a technical solution to remove red eye, then there's a technical problem, and your solution, whether it's an algorithm, does some image processing, and the outcome is that the squirrel doesn't have red eye when it's photographed, then potentially that's patentable. So software is patentable. Like, we do a lot of work for mobile phone companies, telecommunications companies, and a lot of the inventions are based on software. But then there's things that aren't patentable. That, like, mere automation of processes, administration methods, like keeping track of employee data and for HR purposes that could be done in your standard paper filing system. And you're doing, there's no technical problem, there's no technical solution. Sure, it's a neat, it could be a neat interface, but that doesn't allow it to be patented. But I suppose if you can get any nugget of information, takeaway from today is it's important before you disclose anything to ensure that you have your patent filed. Because if you disclose, whether it's on LinkedIn or on some marketing material or publish a paper, once you disclose it, you no longer have novelty. And at the start, that's the criteria for Inventive step. So it's important that you consult your patent attorney in advance of making any public disclosure, because often, especially startups, are very eager to get markets, get the market space, and they're eager to publish. They're eager to get to make some sales, and often they're disclose their foundation IP, without protecting them in the right format. And then once it's in the public domain, it's very difficult then afterwards to maybe build on your foundation IP because it's in the public domain. Again, as I said, an invention, how do they determine is it inventive? Inventive step. Basically, they look at it if a skilled person would consider it to be obvious. So this inventive step, they look at what's already out there, the prior art. They look at the overlap what you're doing and the prior art, and then they look at the new part, the new steps that you've added in, and they'll make a determination: does it provide a technical advantage? So as Phil said, FRKelly's been around a long time. We've been safeguarding Irish innovation since 1927, and we work with a host of companies in different areas. And I thought this is a nice bright slide. It shows some beautiful landscape of Ireland, and it's amazing the level of innovation that's happening here in Ireland. And I think sometimes maybe we don't appreciate all these great companies, but what they all have in common is that they all started with a single patent. They all started with taking the first step to get patent pending status. So it's important, if you do have an invention, you do have a startup, there are always budget constraints when you're a startup, and there's always difficulties when you're bootstrapping a business, but you should make sure that IP is a central part of your business plan. That's what I would say, and make that determination early. And so you can take those first steps, or know that there's no need to take those steps, but make sure that when you're pitching for an investor or doing collaboration with a multinational, that you can answer the questions about intellectual property. Did you protect your foundation IP? Did you consult your patent attorney? And make sure that the central cogs of your business are protected. And I suppose this is just a brief slide. Why would you patent? Like I often say, startups, I'm never going to take on a Microsoft. I'm never going to enforce my patent against Google or Facebook or whoever. But the reality is that you should see your patents or your intellectual property as assets. They add value to your company. They help secure investment. They warn off competitors. You can use them from a defensive perspective. And a lot of startup companies would use IP for, it gives you some marketing kudos. I'm sure David and Shane will go into other reasons why you would use intellectual property to help protect your business. But these are some basic ones that, it's not about enforcing against a big multinational. It's about adding value to your company, adding assets on your balance sheet effectively. So in summary, the nuggets of what I would say about intellectual property: 2 basic criteria: novelty, feature new, inventive step, must provide some sort of technical advantage over what's already out there. And then you should, if you believe then that protecting IP would help advance your business, then you should consult, you're a patent attorney. There are different types of patents. There's an IP strategy suitable for every IP, for every budget. I won't go into the long list here, but there is an IP strategy for every, and as you grow and as you develop, from a startup or a medium-sized company to large multinational, your IP strategy would also change, and we would advise accordingly. So that's the end of my summary of intellectual property. I think I had 10 minutes or 15 minutes. I think I kept within that time. And now I'd like to introduce you to my colleague, Shane Smith, who will give an overview of trademarks.
Thank you. Thank you, Paul. Yeah, I'm going to talk to you. I haven't much time, 15 minutes. I'm going to talk to you about trademarks. And I'm going to show you an example first of a trademark. Okay, that was obviously our own branding, FRKelly, but this is what we call a motion trademark. And motion trademarks are, I would say, a new category of trademark. They've always been around, but they are now a category of trademark that you can actually register. And I believe that trademark that you've seen is the first motion mark that has been filed with the Irish Intellectual Property Office. You'll see here categories of brands. People like to use the word brands or trademarks. They can be invented words, names, letters, numbers, logos, slogans, packaging, labels, colors, smells, or sounds. And I've shown you a motion mark. Basically, a mark is any means by which you distinguish your particular products and services or activities from those of your competitors. And that can be a combination of all or any of those that you see in front of you there. But not all trademarks can be registered. And if you move on there, Brian, not all trademarks can be registered. So what problems are there in registration? Well, why do you get registration? You get registration because you want exclusivity. And the law that defines what gives you exclusivity basically says you cannot register words, logos, slogans, colors, which people in general should be allowed to utilize, okay? So there are two reasons why you can sometimes encounter difficulties in getting the exclusivity that you want. The first is that obviously you shouldn't be in conflict with somebody else's brand. And this is why it's important to carry out extensive trademark searches before you incur expense in the adoption of a trademark, and then suddenly you get a cease and desist letter and you come to somebody like us and we say you have to stop using it. So get your foundation, the foundation under which you're going to build up your goodwill. Get that right by doing appropriate searches. And our job is not just to conduct these searches, but to analyze the results of these searches. And you can move on there, Brian. The other thing that you have to notice is that because you're going to get exclusivity, as I said, there are certain types of trademarks that are next to impossible to register. For example, it's almost impossible to register smells as a trademark because the smell is not viewed as being precise enough to determine the scope of protection that you would get by registry. So, for example, there was one case that actually slipped through that was the smell of freshly cut grass for tennis balls So when you open this case of tennis balls, you suddenly met with this smell. And that was, you know, that is a trademark. And it's very distinctive, but sometimes trademarks might function as a source identifier, but you cannot register. And again, this is the advice that we provide. We advise on, you know, on clearing marks and the registrability of marks. And if you do have a trademark and it comes within the criteria of a type of trademark that can be registered, then you should register it. Because in the absence of registering a trademark, it's very, very, very hard to enforce unregistered rights. And there is a mistaken belief, but widely held, that, for example, if you register a company with a particular name, or if you register a business name, what we call a business name or a trade name, then that gives you rights. They don't. The rights are obtained through trademark registration. And you can move on there, Brian. And trademarks are, when you register a trademark, in general, it's on a country by country basis. That's the general rule. Now, there are a couple of very large exceptions. You can register an EU trademark. That's a single country embracing all countries of the European Union. And so, for example, if you want to protect your mark in the UK now, you're going to have to file both an EU and separately a UK trademark application. There is also what's called an international trademark registration system. It's a little bit of a misnomer because it doesn't cover all countries of the world. It covers a lot of the major countries, but a lot of the African countries, South American countries, Middle East countries are not members. But again, you know, FRKelly there to advise you on that. And it is a centralized system for registering a trademark in a number of countries. And when you get a trademark registration, you get exclusivity against anybody who uses the same trademark or any other mark which is likely to cause confusion. So when you register a trademark, you have to identify the activities that you're going to be engaged in under the trademark. And even identical trademarks, they can coexist, held by different people, where the product areas are sufficiently different. So for example, you might know the trademark Punch. The trademark Punch, again, developed down in Cork. It's a shoe polish, but there's also another company using Punch for herbicide. And you may well know the historical, no longer around magazine called Punch. Again, all coexisting because they are sufficiently different. Trademarks have to be, when you get a trademark registration, you can use the little R symbol, which denotes registration, and that is a deterrent against other people. Trademarks have to be renewed every 10 years, but they can keep on, unlike a patent, they can go on indefinitely, provided you pay the appropriate renewal fees. And the other thing about a trademark is there is a use it or lose it policy. So there is an obligation on the trademark owner to use their brand. If you don't use it for a 5-year period, then anybody can challenge the trademark registration and claim non-use. I see in the chat room there are a couple of questions. One was the appropriateness of trademarks to the fashion industry. And again, trademarks really encompass all industries, absolutely. And definitely the fashion industry. And people can register the logo, the word, anything that you build up your goodwill under through your identity. You should be coming to talk to people like us about, you know, how can we protect that particular identity. One of the questions in the chat room was the difference between a trademark and trade dress. Well, trade dress is really more an American term. It's not used very much in these isles. It's more American. But really, trade dress is really a type of trademark. It's a trademark, for example, if you have the layout of a petrol station or the layout of a restaurant, and you know it is distinctive, then you can register that as the Americans would call it, trade dress. You can move on there, Brian, please. So, you know, it is a means of generating income. You do want people to repeat business, and the repeat business arises because people recognize your branding. You've built up goodwill under that branding. They like their first experience, or they haven't had a first experience, but somebody has recommended them to you. And you know how do people make that recommendation? They make it through your identity. They say, go to FRKelly. They will give you the answers. So that is how you must protect the goodwill that you're going to create through your endeavors. And Brian, we'll move on. And of course, a trademark is a property right. It's what we call intellectual property, but it is a property right. So the most tangible way of protecting that is to register it. And then if there's an ownership change, then it's very simple. You transfer the ownership, and then you record that transfer of ownership on the register. And it's very, very, very straightforward. And of course, as a property right, again, it can be licensed. And again, you know, the terms of a license agreement are a business decision between two people. But at the end of the day, once the business terms have been agreed, you do come and talk to people like us, or you should, to make sure that that is what you agree between yourselves is properly documented. So that's as much as I've got time for. I've answered some questions as I've gone through. Of course, I'd be delighted to answer others. I'm going to pass you over now to my colleague, David Brophy, who is going to talk to you about copyright and design law, in which he has considerable expertise. And there is, of course, an overlap between various forms of intellectual property. So something could be patentable. You could have a branding for it, or indeed the shape itself could be the brand, or you could register it as a design, and indeed it could also have copyright protection. So although we are talking about all of these separately, they do sometimes all come into play together, and that's important to bear in mind. And when David's going to talk to you as he is now, you will see some of the things that he's going to talk about. You might think of that they're brands or trademarks because they're a logo, but they are also designs. Over to you, David.
Great, thank you very much, Shane. So you're seeing my slideshow, I hope. There are a couple of other questions, Shane, on trademarks I saw coming up in the chat, but maybe we will come back to those at the end. I'm here to talk to you, as Shane has said, about designs and copyright, which are the other major category of IP. And I want to start off talking about designs. They are known as the Cinderella of IP, because for a long time they have been ignored and unloved, and they haven't been invited to the ball like the ugly sisters of patents and trademarks. But they're coming more and more into focus now because of some high-profile disputes, and people have been very successful in stopping copying using design rights and copyright. So that's what I want to just outline, what you can protect and how they might be relevant to your business. Design rights, they protect visual appearance. So there is an overlap with trademarks. There can be an overlap with patents in the sense that a product can both look good and work well, and so you could have a patent on the functionality and design rights in relation to the visual appearance of it. But you can see here that it can be all sorts of products. There's very little limitation on what you can protect by a design, as long as it looks different from what's gone before. So not only physical products, but also you can see that there's a logo there or a screen icon, a digital design which is protected. And I wanted to just talk about that as well. In Europe, we have two kinds of designs. We have registered design rights and unregistered design rights. And the unregistered ones you get automatically because there is no registration process, but they don't last for a very long time. So they last for 3 years as opposed to the 25 years you can get when you register a design. There was one question, I think Lucy had a question about what protection you would get in the fashion industry for an item of clothing. This is an example where Karen Millen, the fashion designer and the fashion chain shop, they had introduced the shirt that you can see on the left. And Dunnes Stores, as Dunnes Stores are prone to do, decided rather than designing their own shirt, they went into Karen Millen, they bought all this shirt in various sizes, and then they sourced the same fabric or a very similar fabric and made, you know, a direct copy. I mean, there was very, very little difference, as you can see. And Karen Millen hadn't registered the design of their piece of clothing. So they went to the court relying on their unregistered rights, and they were successful. So the courts agreed that they had unregistered rights. By putting this on the market, they were entitled to protection against people copying their design, and they were successful. It went all the way to the European Court of Justice, who agreed that they did have design rights in this. So, you know, to answer that initial question, certainly in the fashion industry, this kind of product is protectable as a design, and it would be protected as a registered design if you thought something had a longer life than 3 years. But it's certainly, this is the appropriate form of protection. And there may also be trademark protection for the brand that you use to market your fashion items. When we look at registered designs, the obvious advantage is that they last for 25 years. So if you have a product that's going to be on the market for more than 3 years, you want to get longer term protection for how it looks, and registered designs give you that. The other big advantage they give you is that you don't have to prove that you copied, that the infringer has copied you. So Karen Millen had to have proof in court that Dunnes Stores had copied their design. If they had a design registration, they wouldn't have needed to do that. They would literally go into court, hold up the two shirts and say to the judge, this is our registration, this is what Dunnes Stores are selling. If you agree they look alike, then we win the case. And that's how simple design registrations can be. So it gives you a lot of strength, and it's very quick and easy and relatively inexpensive to get that form of protection for Europe. There was one question I saw in the chat just before I started speaking about the cost. You know, you would be able to protect a design for €1,000 for all EU member states for at least the first 5 years, and then you could renew it for successive 5-year terms. So you get quite a bit of bang for your buck with that. One of the important things about designs is that you can protect the whole of a product, or you can select out different parts of a product for protection. So you can see there's the entire teapot is obviously protected. You can see in the second one that they don't have the lid shown. So they've got protection for the teapot without the lid. And in the third one, then they've abstracted it further away to the area of the rim with the handle, and then just the handle on its own. And each of those is separately registered. So a company, for instance, that comes along and copies the detail of the handle with a different shape of teapot body would infringe the fourth registration. If they copy more of it, they will infringe the other registrations as well. So companies will use this, if they're clever, to pick out what are the attractive or the important or the innovative parts of the appearance of my product and get registrations for those individual bits in anticipation that someone might copy them. What does a design registration look like? Well, traditionally, this is the sort of thing that you would see in a design registration. There are drawings done showing the product from each side, and with designs, what you see is what you get. It's not like in patents where you have a written description. You simply put in your drawings, and that's what's compared against the infringement to see if there is infringement. You can see here two other examples. One of them is this car, and an interesting thing about this and also about the iPhone is that the wheels of the car are shown in broken outline, and the entire back of the phone is shown with broken lines, and a lot of what's on the front and on the sides. And what that is a shorthand for saying we're only protecting the parts that are shown using solid lines. So it would be an infringement of the design registration for this car to make another car with the same body but different wheels. And similarly with the iPhone, in this registration, you can see that all that actually is protected is the curved bezel around the edge and the circular home button. So it doesn't matter what the back of a competitor's phone looks like. If you copy these parts of it, you will infringe Apple's design. And Apple have a bunch of design registrations for each model of their iPhone along those lines. What Apple also do, which is, you can learn a lot by looking at how the big companies manage their intellectual property rights. What Apple do, because they can protect graphical designs, graphical symbols and icons and screen displays and so on, what they have done is to stop Samsung and other Android competitors from copying the look and feel of their iOS interface. They have registered individually all of these individual elements. And these are just 4 out of hundreds of registrations they have over different parts of the screen display at different times. And what they're really doing is they're setting up all these registrations almost as barriers that people cannot pass over. So if you want to create a similar looking interface, you can have a slide to unlock button, but it can't look like this. And you can have a recording icon, but it can't look like this one, and select and paste and so on. So by doing that, they force the competitors to make lots of small decisions to make parts of their interface look different, with the result that the overall look and feel of the Apple interface is very distinctive and very different. This is an example from Microsoft. Obviously, you'll recognize this as the Word icon and the Word logo, and they have that registered as a design. And then they also have a more abstracted version of it, where they don't have any color shown, and they have shown the W with broken lines. So effectively, they've got protection for this shape that you can see regardless of whether you have any letter on it or a different letter, and regardless of what color you make it in. So that's again an example of a company being clever about how it protects its digital assets. You can protect moving designs. So just as Shane has said with motion marks, you can protect that. It can also be done in the design field. This is a Nokia, I think it's a, as a screen disappears or closes down, this little cute little icon comes up, and that animation is protected as a series of figures. So why do you register your designs? Well, it's protecting against copying is the most obvious one. You're also using it as a deterrent against competitors. A lot of registrations, whether it's patents, trademarks, designs, you don't know who you have deterred from copying, but the fact that you have a registration makes people think twice about getting too close to what you have. So it can be very useful to have it, and it just stops people, makes them think twice by saying you've got registered IP. It allows you to get registered IP on your books, which can be very helpful for investors and for showing that your business is taking its IP seriously. And with designs, it's as I said, it's, I think, relatively fast and relatively inexpensive. Then with copyright, which is the second aspect I want to talk about, people will have very strong feelings about whether, whether copyright is appropriate, whether it's too long lasting and so on. But as a business owner, that's not your concern. I mean, copyright is what it is, and you need to understand it. It covers lots of areas of creative endeavor. And most of these, for most companies, are of little or no interest. But there are a few that seem to impact on most businesses that we deal with. The first one would be literary works. And that's not just books, it's also the written materials that you produce, manuals, handbooks, stuff for your customers, stuff for your staff. All of that is protected automatically by copyright. Computer code is seen as being a literary work. It's a legal fiction that it is literary. Its original is protected in this way. And then almost every business will have a website, and there'll be written material in that, and that's also protected using copyright. For artistic works, again, you may create artwork which is in your customer materials, in your brochures, in your leaflets. You will often use photographs, whether you take them or not. You will use photographs in your business, and you need to be careful about the copyright in the photographs that you decide to use. There will be copyright in graphical symbols that you create or that you use, like your logo. And again, the website will have graphical materials that are protected as artistic works. And then databases, which are protected under copyright law, not for the information that they contain, not for the content that they contain, but for the collection, for the fact that you've put together this material and you've collected it and organized it systematically. The law will protect you against that, even if the pictures of the individual valves and connectors on the previous page, even if there's nothing creative about those, the fact that you put them all together will give you database rights. And you can prevent people from going into your database and taking bits and pieces on a repeated basis. For businesses, one of the main things you want to know about copyright is how not to infringe copyright. It's where a lot of businesses run into trouble. It's very easy to avoid infringing copyright. You will only infringe copyright if you actually copy someone. You can't infringe copyright if you independently come up with the same as Walt Disney came up with. You only infringe if you copy what Walt Disney did. So you can create your own work, and that's a very straightforward way to make sure that you're not copying someone, or you can get someone to create it for you. But what you can't do is just go out there, find stuff you like the look of without checking that it's free for use or that you can get a license for it, and then just start using it in your business. If you do get someone to create for you, you've got to be very careful that you actually own it. And it's one of the first things, if you're ever trying to get investment in a company or sell a company, it's one of the first things they will look at is whether you have, as part of the due diligence, whether you own your IP or whether you have problems with the IP that you're relying on. So if someone creates something for you and you employ them, then usually you're okay. Normally you own it. If they created it as part of their job, you will own it as their employer. You also want a contract of employment that says that that's what's going to happen, just to make sure that there's no misunderstanding. The bigger problem that we see is when people get someone who is not an employee as a contractor to create IP for them, to write a website, to write some code, to take some photos for them that they subsequently use on their webpage and so on. If you've got a contractor, you have to get an assignment. You want them in writing to say, I'm doing this for you, you're going to pay me this much, and then you will own the copyright in it. And it doesn't have to be a formal document, but it does have to be there in writing and very clear that you own the copyright. And it can be retroactive. So if you're looking at your own business saying, well, we got this code written and we never really followed through on the legals for it, do it now and get it sorted now, and you can do it retroactively. And usually it's cheaper to do it now than when the person who wrote it for you realizes that there's a lot of money at stake. They start misremembering what you agreed. How do you get copyright? It's very straightforward because there is no registration involved for copyright. It's an automatic right that it comes into being as soon as you create the work. So as soon as you create it and record it somewhere, you have copyright in it, as long as what you've done is original. You do have to keep records so that you can show that you created it and when you created it. you should mark your works to say that it was you who created it and when it happened. And repeating again, get a license or an assignment for everything that you use as part of your business to protect yourself. And that's the quick view of copyright and design. So thank you very much. And I think we can probably take any questions that have popped up in the chat.
So actually, we have dealt with quite a few of the questions on the chat. Certainly, if any attendees have particular questions they would like to raise, now's a good time to do that.
Philip, I see one of the questions is along the lines of, if you do your search of a trademark and you find the trademark is abandoned on the register, does that mean that you can now come in and take it up? And the answer to that is generally yes, but not always. So first of all, when you go to see and you see that a trademark has been abandoned, there are in different countries, including in the European Union, a grace period for paying a renewal fee. So somebody might not have paid the renewal fee, which is every 10 years, but might still be allowed to do so up to 6 months later. So that's one thing. But the other thing is that there is also sometimes unregistered rights in a trademark. So that if somebody, for whatever reason, doesn't renew a trademark registration or has filed an application which they don't progress to registration, it doesn't necessarily mean that they don't have goodwill under that branding. They could be residual goodwill. Sometimes companies do go bust. They don't pay the renewal fee of a registration that comes in, but that brand may still be recognized in the marketplace. And so, for example, somebody may purchase the assets of the company in due course, which includes trademarks, even unregistered, and they could claim unregistered rights. But that is more the exception rather than the rule. So the answer to the question is, in general, yes, but not always. And again, on a case-by-case basis, you should be coming looking for advice on an issue like that.
And thanks, Shane. And then very quickly, David, there was a question about cost of registering a design in Europe. You probably see it on the chat.
Yes, so to register a design in Europe, I would say €1,000 would cover you for the entire process from start to finish. That would be a typical cost. It can be, if you've got a few different designs at the same time, which are in a similar field, then it probably won't cost you $1,000 for each one. It would be cheaper to get the second and third ones because we can start to group them together for the registration process. But that would be a ballpark figure to get registration.
Okay, thanks, David. And just one last question. There was a question you'll see it on the chat about requiring an assignment where the likes of Fiverr or Upwork, where you can employ a freelancer to do a piece of work, cover assignments. Can you see that there?
Yeah. So you would, if you're ever going to use one of those services, you want to be very clear. Look at the terms and conditions. That you know, there will be standard terms if you use Fiverr to get someone to make something for you. Check that as part of the conditions that you own what comes out at the output of it. If you're not happy with what it says, then don't use it, because you know, there was one case years ago where a freelance designer created a logo for Doc Martens, and he only ever agreed for it to be used on the shelf, not actually as the logo for the boots overall. They liked it so much they started putting it on the boots and on the labels and so on, and it's a very expensive case to try and get the rights back off the designer.
Philip, I just wanted to mention one other thing in relation to costs. David has mentioned that a unregistered design lasts for 3 years. A registered design lasts for a maximum of 25 years. And you do have to pay a renewal fee every 5 years. It's not sizable, but in order to keep it enforced, you do have to pay. And that's another thing about all your IP and managing it properly. You need to keep track of renewal dates, both on, on patents, designs, and trademarks. Sorry, okay.
Okay, thank you. Thank you, Shane. So we're coming up to 2 o'clock, and it's really lunchtime over for everyone. So if people have any other questions, they're welcome to contact us on our website. We will be making the slides available via the Republic of Work, and they can be sent out, and our contact details will be on those. And hopefully soon, we'll be able to talk to people about intellectual property over a coffee in the Republic of Work or in Dublin or somewhere else once the vaccine gets going. I would like to take this opportunity, first of all, to thank everyone for joining us this afternoon. And secondly, in particular, to thank the Republic of Work, and in particular, Angelica, for her work and effort in arranging the meeting today. And I'd also thank Paul, Shane, and David for the presentations this afternoon. So really, finally, it's just to sign off. I would just like to say, wish everyone a safe and a Merry Christmas. And we'll end the webinar here, and certainly look forward to talking with people in the future, and we can certainly contact people by email. So thank you very much indeed.